Welcome to the Firearm Firm channel. According to a recent federal court decision, being a habitual user of marijuana may no longer prevent you from lawfully exercising your right to bear arms. Before we dive into this great court decision, be sure to show your support for the Second Amendment by clicking the like button and the subscribe icon in the bottom right hand corner of this video. The Firearm Firm channel is definitely growing, but the analytics show that almost 90% of the viewers watching our videos are not subscribers. So, if you fall into that percentile, please take the 2 seconds needed to become a subscriber. Since the United States Supreme Court's ruling in New York State Rifle and Pistol Association versus Bruen, courts have slowly been tearing down some of the restrictions that have been placed on the Second Amendment. The latest victory came out of Oklahoma this past Friday, February 3rd, 2023, in the case of United States versus Jared Harrison. Mr. Harrison was pulled over for running a red light, and when the officer approached his car, he noticed the odor of marijuana coming from the inside. Law enforcement eventually searched Mr. Harrison's vehicle and found marijuana in various forms and a loaded revolver. Mr. Harrison was arrested and charged in Oklahoma State Court for possession of marijuana and drug paraphernalia. Several months later, a federal grand jury indicted Mr. Harrison for possessing a firearm with knowledge that he was an unlawful user of marijuana in violation of 18 U.S.C. 922 subsection G3. Harrison then filed a motion to dismiss the indictment based on the Due Process Clause and Second Amendment grounds, arguing that the government cannot affirmatively prove that the restrictions found in 922 subsection G3 are part of the historical traditions that define the outer bounds of the right to keep and bear arms. Ultimately, the court agreed and dismissed the indictment against Mr. Harrison, finding that 18 U.S.C. 922 subsection G3 violated his Second Amendment rights to possess a firearm. The question the court focused on was whether stripping someone of their right to possess a firearm solely because they use marijuana is consistent with the nation's historical tradition of firearm regulations. In answering this question, the court first looked at whether the plain text of the Second Amendment covers Mr. Harrison's conduct of possessing a handgun. The government position was that the relevant conduct is keeping and bearing arms as an unlawful drug user or addict, but the court noted that there was a problem with the government's position because Mr. Harrison was charged under a statute that criminalized mere possession of a firearm, and therefore, for purposes of analyzing 922 subsection G3, the relevant conduct is possessing or keeping a firearm rather than carrying or bearing a firearm. Next, the court analyzed and concluded that Mr. Harrison was part of the national community and thus part of the people to whom the Second Amendment guarantees the right to keep and bear arms. Now, the government argued that marijuana users are lawbreakers, and lawbreakers therefore are not part of the people whose rights are protected by the Constitution. But the court found that this sort of carrying out of a subset from all Americans is exactly what the U.S. Supreme Court in the case of District of Columbia versus Heller rejected. In Heller, the court wrote, "Frankly, it's not even clear this is a carving out of a subset as much as an outright declaration of the federal government's belief that it can deprive practically anyone of their Second Amendment right. Who among us, after all, isn't a lawbreaker? For sure, there may well exist some adult who has never exceeded the speed limit, changed lanes without signaling, or failed to come to a complete stop at a stop sign, but they are few and far between." Therefore, the court found that the Second Amendment's plain text covers Mr. Harrison's conduct, possessing a handgun for self-defense, and the Constitution presumptively protects that conduct. Because the court found Mr. Harrison's conduct was protected by the Second, the burden then shifted to the government to demonstrate that prohibiting marijuana users from possessing firearms is consistent with the nation's historical tradition of firearm regulation. Now, the government did a great job putting forth effort to show that the restrictions of 922 subsection G3 was part of the nation's historical tradition of firearm regulation, but the court was not persuaded. If anyone is interested in reading the government's argument and why the court rejected all of them, I will attach a copy of the order down in the comments section. Although this is a great step in the right direction, don't get too excited just yet. I have no doubt that the government is going to appeal the district court's ruling to the United States Court of Appeals for the 10th Circuit. Even if the 10th Circuit upholds this decision, it would only be binding on the federal courts in Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming. But this decision is still a huge victory and a step in the right direction for the Second Amendment. Be sure to tell us what you think about this recent decision down in the comment section, along with any questions you have about this video or any other Second Amendment related question. Until next time, stay armed and educated.